Ready? Okay. Good morning, Chair Penner and board members, colleagues, and members of the community that are here with us today. I'm Allison Ganter. I'm the Deputy Director of the Facility Standards and Operation and Research Divisions. I'm really looking forward to sharing the FSO responsibilities with all of you this morning. I'm quite proud of our team and the work that we do in the field. We've adapted a lot in the last few years to a more enhanced inspection process, better data collection measures, more time out in the field, and we'll continue to improve our processes as we go along. I welcome questions and feedback. I'll talk about our inspection processes. Katie will talk about SB 519, and then hopefully for questions and feedback at the end, and I welcome all of those. So oh boy. I won't touch the microphone. What I'm going to talk about this morning is our authority for inspections. Some of the different types of facilities, or all of the different types of facilities that we inspect, our enhanced inspection process and the types of facility inspections we conduct. Talk about the inspection process in a nutshell, what it looks like when we begin and walk through and then end an inspection. I want to share a little bit of what we do as opposed to what we don't do in our role. And then I'll hand it one more thing, talking about other areas of oversight in local detention facilities. There are often questions about what other entities or agencies or inspections or investigations happen in local detention facilities. So we have a handful of those to talk about as well. Then we'll hand it over to Katie for a discussion on SB 519, and we will both be available for questions. So I will.
The only thing I would add, Allison,
Sure.
just at this juncture is we're actually going to have public comment following our closed session, and we will address any information items at that time because we're going to have a continuance of information items.
Okay. Thanks. So first, here is the BSCC authority for adult detention facilities. We do have the responsibility to adopt and revise regulations. That's in Penal Code Section 6030. Every 2 years, we're required to review and, if necessary, revise. This is very specific to the adult regulations. The last revision that we completed actually was effective in January 1st of this year in 2023. And just for clarity, we talk about Title 15 and we talk about Title 24 inspections. Title 15 are the operational regulations. They guide things like safety checks, medical mental health, admission release, those sorts of things. So when you hear Title 15, we're talking about operational regulations. Title 24 are the physical plant regulations. And so that's the distinction between the two. And a really quick note about Title 24, just because this is our opportunity to share as much information possible as we can in a short amount of time. When a facility is built, they are assigned a version, a year, an effective date of Title 24 regulations. So if a facility was built in the 70s and they are under Title 24 regulations from the 70s, unless there's significant build or remodel, they remain under those standards. They're not required to come up to current Title 24 standards. It's an important distinction with Title 24. Title 15 is not like that. An agency has to come up to the Title 15 revisions every few years. Our inspection authority is in Penal Code 6031.1. This includes all local detention facilities. The statute requires us to conduct at a minimum biennial inspections. I'll talk about this a little bit in a moment. We are currently conducting annual inspections. Statute is minimum biennial. We do annual inspections. And then finally, we review all plans for construction. This is in Penal Code Section 6029. This also applies to the juvenile detention facilities. Anytime an agency wants to build a brand new local detention facility or remodel or affect any of the spaces where Title 24 applies, the agency needs to have plan review done through the Board of State and Community Corrections. And what that includes is a letter of intent, the agency signaling that they would like to build or remodel. BSCC staff reviews the plans at each stage, from initial drawings to the final plans that are used for construction. We approve Title 24 throughout each of those stages. We do construction visits, and then finally we conduct a pre-opening inspection. So from start to finish, we're watching the progress to make sure that agency, that facility or remodel is in compliance with Title 24. The authority for juvenile facilities is mostly the same. There are differences. We have similar responsibility to adopt and revise regulations in Welfare and Institutions Code 210 and 885. They're just split in 210. The authority is for the juvenile halls and the secure youth treatment facilities. And in the 800 section is the camp facilities. And I'll talk about each of the types of facilities in a moment. Inspections, juvenile hall and SYTF, same responsibility at a minimum biennial. And the camps are also located in that 800 section. Again, we are conducting annual inspections of those juvenile detention facilities. What's different in the juvenile, in our juvenile responsibilities, in the Welfare and Institutions Code, section 209, we have the responsibility to make determinations of suitability when there are items of non-compliance and approved corrective action plan is not submitted, or those items of non-compliance have not been corrected. So that's where there's a significant difference between our responsibility for adult inspections versus juvenile detention facility inspections. The types of responsibility for inspections, regulations, plan review, and suitability. So what types do we have and how many of them are there? There are 450 adult detention facilities in our state. Quick overview of the breakdown. The type 2, the kind of light blue wedge, and the type 3, tiny little wedge. There's 118 of these type 2 and 3 local detention facilities. These are what we commonly refer to as county jails. They are type 2 facilities are intended to be pre-sentenced facilities, and also they've morphed over the years to being a combination of sentenced and non-sentenced individuals. Type 3 facilities are for sentenced individuals only. There's only 2 of those that we know of left in the state. But again, type 2 and 3 facilities, county jails, there's 118 of those. There's 3, that little tiny purple sliver, type 4 facilities. Those are work furlough facilities. There are currently 3 in the state. The yellow wedge, 86, type 1 facilities. These are police departments and sheriff's substations. They are typically smaller, shorter term facilities. They can hold people up to 96 hours upon their arrest. Again, short term, police department, sheriff's substations. Temporary holding facilities, that's the dark blue wedge, 126. Those are also police departments and sheriff substations. They can hold people up to 24 hours after arrest. And then finally, court holding facilities, 117 of those. Those are run by our sheriff's departments, and those are where people are held during, before, after court appearances. We currently have 10 inspectors to inspect those 450 facilities, adult detention facilities. Again, every single year we go to each of those facilities. Juvenile detention facilities, there are 133 of those. The largest, it's making me think of pie. It is a pie. 44 juvenile halls, the green section, those are typically pre-adjudicated facilities meant to be short-term facilities for young people. We have 39 camps, that's that yellow slice. Those are post-adjudication facilities for young people. 47 secure youth treatment facilities. Those are the newest type of facility here in California. All of those facilities are carved out of existing juvenile hall and camp facilities. None of those are brand new standalone facilities. I wanted to make that distinction, but there are 47 of those. And those are like camps post-adjudication, but also a different type of treatment facility intended for youth with higher needs. And then we have 3 special purpose juvenile halls, which are very temporary in nature, and a young person can be held up to 96 hours. 5 inspectors for those facilities across the state. Again, we're doing those inspections of those 133 facilities on an annual basis. So our enhanced inspection process, which really our inspection process. In the 2021 budget, Governor Newsom directed the BSCC to more actively engage with counties when non-compliance is discovered. And to that end, we implemented this enhanced inspection process that includes, again, annual inspections. We are in the middle of the 2023-2024 biennial inspection cycle. Year 1 is 2023. And again, every facility received we're almost done, received a comprehensive inspection. That means that they got inspected for every applicable Title 15 and 24 regulation from top to bottom. Next year, year 2, every local detention facility will also get an inspection. There'll be a targeted inspection targeted on items of non-compliance, items of concern that are identified that need looking at, physical plant issues, those sorts of things. They will be targeted, they will be focused. But again, every local detention facility will get an annual inspection next year as well. We are also conducting unannounced inspections. This is something that was part of the enhanced inspection process. In addition to those annual inspections, unannounced inspections are in addition to those inspections. Reasons for unannounced inspections can include follow-up on items of non-compliance, issues of concerns that have been identified through various sources, following up on compliance drift. Sometimes a facility is having issues that if they don't correct those issues, they could lead to non-compliance in the future. Unannounced inspections will focus on those as well. And also physical plant and conditions of confinement are also sometimes included in unannounced inspections. 2023 was the first year that we began doing those unannounced inspections. Reporting to the BSCC board, there's always been a suitability process for the juvenile detention facilities that included submission of CAP and verification of corrective action with items of non-compliance. And with this enhanced inspection process, we added that same component to the adult detention facility inspections, where we're actively requesting corrective action plans from adult agencies, from sheriff's departments and police departments, and also actively following up on corrective action. Where there's significant items of concern, BSCC staff can seek approval from you all, from the board, to request that sheriff or chief probation officer or chief of police come before the board and talk about those items of non-compliance. And of course, all of our reports are posted, and you have seen us provide an update at every board meeting related to the current items of non-compliance. So again, the enhanced inspection process was about getting out into the facilities more frequently to conduct inspections, do follow-up, unannounced inspections, transparency and accountability. And those processes have all been added to our inspection process, and we've been doing those since 2023. Oh, and also ability for technical assistance. Again, just having the ability to go out to facilities either on an as-needed basis or again to follow up on items of non-compliance. That is also a part of our enhanced inspection process. So I know that some of you have been through inspections, probably some more recently than others. Wanted to give a quick overview. That's where I'm using the microphone. Excuse me 1 second. Okay. So a quick overview of what the inspection process looks like from start to finish. We do, and again, this is for every local detention facility inspection. 450 plus 133 facilities. First, we conduct a pre-inspection briefing. This happens before the inspection. It's an opportunity to make sure that the facility understands the material that we're going to be asking for in the facility inspection. It's helpful, especially during a comprehensive inspection, to have access to the documents and records that we'll need. So we hold a pre-inspection briefing before we conduct the actual inspection. Policy and procedure review will happen before we go on site. You've seen policy and procedure manuals. They're pretty lengthy and detailed. So what the field representatives will do is review policy and procedure and do a pass-through to see if policy and procedure meets Title 15. Before they go to the facility, and they can generate any questions that they have for the administration when they get to the facility. The on-site inspection, this is taking what we've reviewed with policy and procedure and making sure that policy and actual practice are aligned. We're looking for evidence that the agency is compliant with Title 15, not just that their policy passes the test. So what we do when we're on site is we review documents. We do ask for samples, and we will also ask for agencies to pull samples, on site as well. So we get a combination of some data that is pulled before, and we're also going to ask for data to be provided to us while we're there. We spend a lot of time walking through the facility. We interview people that are housed in those facilities, both the young people and the adults. That's a really important way to get information about compliance with regulations. We also interview staff, observe physical plant conditions while we're walking around, and then we have the opportunity to look at live data. Not everybody does safety checks with a piece of paper and a pen anymore, but those types of things that are available at officer stations, we will look through. It's a really good way to get a snapshot of what's happening in the facility at that time. So the on-site inspection takes the longest, obviously, and again, it's making sure that we can see that Title 15, that the agency is, or unfortunately isn't, in compliance with Title 15 and Title 24, that no changes have been made to their physical plant that affects their compliance with physical plant regulations. And then the exit briefing. This is a really important part of our inspection process, because if there are items of non-compliance, that's when we are able to provide the facility administrator, the sheriff, the chief probation officer, or the chief of police with notice of non-compliance. That document is called the IIR, the initial inspection report. And that exit briefing, again, is where we provide the initial inspection report, and we notice the agency if there are, in fact, items of non-compliance, and we can start the clock for receiving a corrective action plan and ultimately being able to verify that corrective action in a certain amount of time. And then, of course, there's follow-up. We often conduct on-site inspections, certainly if there are items of non-compliance to verify. We review documents, again, to make sure that items become in compliance, or to review continued compliance. If there's technical assistance, if an item came up while we were on inspection and the agency needed us to come back at another time, we'll do that follow-up as well. Typically, it's on site. That's what our goal is, to be able to have our team members there to interact with the facility staff. But sometimes it's the magic of email and communication. So that, in a nutshell, in a police department, it might take several hours to do an inspection. But again, we have the time before that spent on policy and procedure review. In larger facilities, it can take several weeks to complete an inspection. So a summary of what the BSCC does: we do inspect for compliance with Titles 15 and 24. We do assess suitability for juvenile detention facilities. We adopt and revise regulations, and we conduct plan review. And the distinction between what we do and what we don't do is we don't develop agency policy and procedure. Title 15 is the framework for the agency to develop those policies, the policies, procedures, and actual practices that Title 15 require. We don't develop them for agencies. Really, really, really important distinction that I repeat a lot. We can't compel compliance in adult detention facilities. Different story with suitability in juvenile detention facilities, but in adult detention facilities, we cannot compel compliance. We cannot sue agencies, we cannot close facilities, and we don't issue sanctions. We don't conduct investigations, again, related to Title 15 and Title 24. We don't investigate complaints. We get a lot of complaint letters, sometimes from family members, sometimes from people that are housed in local detention facilities. We do our best to respond to those with what we can do. If it's a Title 15 issue, the inspector responsible for that agency will work through the issue with the facility administrator and also respond to that person. And we also try to let people know who they can reach out to if they have a complaint about conditions in detention facilities that don't relate to BSCC responsibilities. We don't inspect outside of Title 15 and Title 24. There are many, many laws, many other regulations that apply in local detention facilities. We stay within the boundaries of Title 15. We cannot call an agency out of compliance for something that's not in Title 15 or 24. And we don't enforce consent decrees. If an agency has a consent decree, a stipulated judgment, some other sort of settlement, they are responsible for making sure they meet the terms of those settlements and consent decrees. Sometimes they align with Title 15 and there'll be some crossover, but a lot of times they don't. And that's simply not our responsibility as the BSCC to enforce those or inspect for those. And finally, some additional oversight. And this is helpful to share too, because sometimes there are questions about, well, who does this? Who does that in a local detention facility? And there's a lot of other areas of oversight in these facilities. So fire and life safety, the state fire marshal or the local fire authority is required to do a biennial inspection and do a fire clearance of every local detention facility. They are required to send those to the BSCC. We don't always get them, but we do ask. We ask for copies. And an agency can be found non-compliant with Title 15 if they don't have fire clearance. Public health, medical, mental health, nutrition, environmental health inspections, the grand jury, Juvenile Justice Commission, those inspections happen each year. Juvenile Justice Commission doesn't necessarily inspect a county jail, but they will inspect a police department or sheriff station lockup. We send our inspection reports to those three entities, to the health department, to the grand jury, and to the Juvenile Justice Commission. They are also required to send their reports to us, I think with the exception of the grand jury. So there is distinction between what those entities inspect and what the BSCC inspects, but those reports can often inform one another. But we do try to stay in our own lanes with those and not inspect something that another agency is inspecting, and vice versa with those outside entities. State auditor, attorney general, criminal investigations are done by the district attorney, Disability Rights California, federal courts. These are all organizations that may be able to compel an agency to action. Those entities can do inspections, conduct investigations. I'm sure you're all familiar with the operations of those oversight bodies, and also accreditation organizations. If an agency chooses, they can choose to meet the standards of an accreditation organization, like the National Commission on Correctional Healthcare is a popular one. That is a summary of our responsibilities, the facilities, the types of inspections. I'm going to hand it over to Katie to talk about Senate Bill 519, and then I think if there's questions from members, we can do that. So Katie?
Thank you, Allison. If you wouldn't mind just doing the slides for me. This is
Sure.
a very high level overview, basically a planning update on Senate Bill 519, which we spoke about briefly at the September board meeting. So I just have a couple of slides. Next slide, please, Allie. So the governor signed SB 519. The bill specifically takes effect on July 1st of 2024. So I'm going to tell you, repeat again what the main components of these new requirements are for the Director of In-Custody Death Review, and let you know that our board will have many more conversations in the new year. When a new bill passes that requires a state agency like ours to establish a new function or set of services, there is a planning process that we engage in to make a request for the staffing resources and the funding resources. We've done that, but that is held confidential until the governor determines and the Department of Finance determine exactly what they want to put in the governor's budget in January. So there's much more to come in the new year. So highlights from SB 519, it creates the position here within the BSCC at the staff level of a Director of In-Custody Death Review. Like the members of this board, well, most of the members of this board are appointed by the governor. All of you are appointed by some entity. So this director position is governor appointed and subject to confirmation in the state Senate. At the highest level, the responsibility of the director, and with assistance from the staff that we anticipate getting next year, will be reviewing investigations of any in custody death incident, which is defined. We're going to have an item on our agenda later today connected to the regulation. I'm starting to slip over into my next slide. So just keeping it on what's in the bill. The director and that office will be responsible for reviewing investigations of any death incident. So in essence, we will be receiving the report from the county detention facility about the in-custody death incident and reviewing those investigations. The director will then be responsible for making recommendations to the sheriff or the facility administrator about the incidents, and that might include changes to policies, procedures, and practices, facility upgrades, staffing considerations, the delivery of medical and behavioral health services, and operational and capital funding requirements. So that I'm specifically reading from the bill right now. So that's the most important thing to go off of at this point. After that investigation is completed, we will provide recommendations to the county, and within 90 days of receipt, the sheriff or facility administrator will identify those recommendations that will be implemented, will provide a timeline for implementation, and discuss the anticipated cost of implementing. They will likewise identify if there are any recommendations coming from the Director of In-Custody Death Review that cannot or will not be implemented. They need to indicate and provide an explanation as to why that won't happen. And our board may call upon the sheriff or facility administrator to respond to discuss the recommendations once they are received. All of the recommendations and reports out of this office will be made public and available on our website. And so I think really that is about as much detail as we have. Next slide, please. As I started to note, we do have later on our agenda today a proposed amendment to the existing regulation on the death in custody regulation, and that simply spells out in a bit more detail what kind of reporting expectations we will have for counties when a death incident occurs, so that our office can fulfill this new function. I mentioned we've submitted what's called a budget change proposal, BCP for short, for the staffing resources, and that will be reviewed and vetted and discussed through the budget process next year, again with the start date of July 1. And we will have much more opportunity for planning and further board conversation next year. So Chair Penner, that concludes my overview, and we'd like to see if the board has comments or questions for any of this presentation.
First, thank you both so much. Those were really helpful presentations, especially Allison. I appreciated yours. When was the last time that number of 15 inspectors for 583 facilities revisited? And is it time to revisit that again?
That's a great question. So it was in the 2021 budget, I believe, we did get we got 14 staff total and we added, I believe it was 7, sometimes my math isn't good. 7 inspectors to our roster. We do have, I believe, 2 vacancies right now. So it was revisited after that budget year in 2021. That that was the last time.
You're very discreet, Allison. It's a huge
Yeah.
lift for a very small number of staff. We do have 2 vacancies
Correct.
and we're pedaling as fast as we can to fill them.
Yes.
I guess the second part of my question is when those 2 vacancies are filled, is that sufficient to do what you need to do? Seems like a tremendous amount of work for a small number of people.
It is a lot of work.
There is, if I'll just jump in, Allison, there is a
Sure.
staffing request, Judge Guard, that will be part of the budget change proposal to fulfill the duties of the Director of In-Custody Death Review. So in order to do that new function, we are asking for new staff. And I think this board may indeed want to have further conversation about the staffing needs. I think that our FSO team does an absolutely amazing job. And it is a huge amount of work. So both things are true.
Oh,
Go ahead.
I have a couple questions. Thank you, both of you, as always. So one of the questions is the inspection process that you laid out. Is that the same for unannounced inspections or does that change
That's
for unannounced?
a great question. So unannounced inspections, obviously, we're not doing a pre-inspection briefing. We typically don't have a chance to review if they've updated their policy. Policy and procedures are available online, so we do have access to some of those. Or if we've, recently reviewed, we can go back and review. What's the same is that whatever the focus is, say we're looking at safety checks during an unannounced inspection, we'll have the same process. We'll walk through the facility. We'll ask for them to pull a sampling of documentation. We'll look at live documentation. We'll talk with staff. We'll talk with people housed in the facility. That portion will be the same. And then the exit briefing would be the same as well. If there's items of non-compliance, we'll issue that notice, the IIR at the exit briefing, and then do follow-up the same. So really the only difference is that we don't provide any notice or do any prep with the agency beforehand. We just show up.
Okay, great. And then I have 2 more questions. The complaints from the families that the BSCC is not able to answer, it's not in our scope. Where do you usually send those complaints? Like I saw the page that you had the additional oversight page, but do you guys know just offhand where's the majority of the referrals to the attorney?
Well, it really depends. We do try to, as best as we can, figure out what they're trying to ask us. Sometimes, it takes a little bit of back and forth to understand what the question or the concern actually is. We will reach out to the facility administrator and say, hey, we've gotten this letter from this person. This is their concern. They may or may not have worked with that individual or that family, but it's just a prompt. We can't necessarily, compel an agency to do anything. Every time that we've reached out to an agency and said we've had a question or a complaint from a family member or a person housed, they do follow up. They usually loop back with us and say, we talked to so-and-so and this is the outcome. So we have a little, record of it. We don't reach out to their attorneys or we just don't have the ability to do much more, but we would recommend, oh, hey, this sounds like an issue with your case or maybe your charges or your healthcare, reach out to these people, reach out to your attorney or, medical staff in the facility. We just try to direct people to the right place, but we don't always know what that is.
Right.
Allison, would this be a decent time to interject that OYCR has an
Oh, that's
ombudsman? And we
yes.
coordinate with them and
Really good
I think we've
point.
had some conversations and there's a planned exchange on what matters may stay in
Right.
their agency or cross over to ours. And so it was, it's a great question because it was a need and I think it has been filled with the advent of the ombudsman.
Yeah, thank
And-
you, Linda.
And then a few years ago, like right at the beginning of COVID, we went and did some inspections. That was fun. So is there opportunity for board members to participate in inspections at this point?
I think we should I mean, absolutely. It's difficult to do an inspection with people, but we can certainly figure out what that looks like. Because we've done it before, and I think it's important for members of the board to be able to see the processes that we go through. So happy to talk about that.
Right. Thank you.
Sure.
Anybody else? Questions or comments? Oh, there you are. Supervisor?
Thank you. Thank you so much for the report. For SB 519, could you just spend a minute talking about how you anticipate the oversight to work? And one of the things I'm interested in understanding is for facilities that already have an oversight board or where the district attorney is involved, how do you see this particular role connected to those other activities, if at all?
This is Katie speaking. Thank you, Supervisor Chavez. I would say that the definition of the role of the Director of In-Custody Death Review is fairly well targeted on reviewing the investigations that, and perhaps you'll see a little bit more closely when we get to the agenda item later today about the changes to our regulation. I would say, and I'm happy to ask our counsel if he has thoughts to add as well. But our focus will be on reviewing the investigations. In certain instances, the director may request permission from the board to do additional investigation. It doesn't seem to me that this contemplates much consultation with others, certainly with in the example of a death in custody. Surely there may be activities going on by the district attorney's office, criminal charges, whatever there might be potentially going on. We would not be, I don't think, involved in that. Our focus is going to be on facility operations and making recommendations to the local sheriff and or detention facility about policies, procedures, and practice modifications that might avoid death in the future. Aaron, anything to add?
No, we're
Okay,
not.
thanks.
So just to thank you for that,
Sure.
Kitty. Does that mean then I guess what I'm really trying to understand is like in custody deaths, there are already so many or potentially so many reviews that have occurred. Are you saying that you would be availed of all of that literature to make determinations as to whether or not there are recommendations that align with the basics around the physical infrastructure?
Not just the physical infrastructure, Supervisor, but also like the practice. I mean, just to
Like
provide.
anything that overlays with those other areas, the 15 and 24.
That's right.
Okay.
That's right. So we might
right.
be looking at things like a person was found, at 11:15 a.m. deceased. And wait a minute, a safety check hadn't been done for 75 minutes. That's an issue, obviously. So it would be very much focused on operational, practical things where we can say, all right, here are some recommendations. Where we can make those, we will.
So one of the reasons, colleagues, that I'm raising this is that, and I'm only deeply familiar with one department, but we now have an oversight to our jails that does an inspection also as part of it, these kinds of incidents. And to your point, it's an interesting point about just making sure that whatever goes forward, that you have access to all of that data that may be above and beyond just what the custody facility produces, but what the DA produces, what our oversight, just again at a local level, or other oversight bodies. That seems like that would be really relevant. I don't know under what circumstances outside of something being the public realm, but I was more just curious as to whether or not you'd have the ability to avail yourself of all of that other research that was done by others.
I think it's a great topic for future discussion as we begin setting this up.
Thank you. And then just one other question, and Ms. Kumpion might have asked it. I had a little bit of a difficult time hearing the response, and that was related to the the unannounced inspections. And what I was curious about is if in an unannounced environment, do you ever have trouble getting access unannounced because it's so infrequent that that happens? I imagine you show up somewhere and you might have people saying, whoa, you're not allowed to be in here. How does that work?
So we haven't yet had an incident where an administrator has said that to us. We do have
great.
permission in statute. We also have a fantastic memo from our executive director, just again, reaffirming the fact that statute,
says, "Let
allows
them
us
in."
to go in
Please,
there.
please.
Just
Okay.
talking with a team member this morning, sometimes we show up and people have other plans of their own, either something unplanned with them or their family, or they're not at the facility. But again, what we've found is somebody has always made themselves available in those facilities to work those things out. I've never seen, and my team has never seen, some administrator say, nope, that's it. Come back tomorrow. We don't want you here today. It's always been, all right, well, we'll get somebody in here and we'll figure it out. It's not been an issue.
And Supervisor, this is
Yeah.
Katie. I would only add that when the law changed, I think it was 3 years ago, we made sure that, all of the elected sheriffs, the probation chiefs, all of the facility
Got it.
managers were aware that this unannounced inspection authority was statutorily granted. And as Allison said, we have not had problems in the field.
And the
Thank you. That's
my
very
final
helpful.
addition is they're not as rare as you think, Supervisor Chavez. I think we're routinely doing unannounced inspections.
Oh, that's good to know. Thank you very much.
Yes.
So one quick question. There was a slide with regard to the BSCC responsibilities was entitled additional oversight. And I didn't see local juvenile court judges mentioned as an additional inspector or.
Fair point.
I thought of that too,
Yeah.
Chief. We should have put juvenile court
Yeah.
judges on that list.
Fair,
Yes.
fair
enough.
point.
And then my second question is related to SB 519. So the director's position, it indicates that authorized representatives of the director may also request records, request entry, has it been considered who those authorized representatives might be, or how that is restricted or limited? Could be members, I assume, of the BSCC.
That's what I anticipate. Authorized representatives of the director, to me, that's the staff supporting the BSCC staff, whether they be inspectors, perhaps our analyst staff requesting documents. So the authorized representatives would be our staff carrying out the work of the director. Right, Aaron? Just say yeah.
Well,
So that actually, that causes a follow-up question.
Yes.
My concern is that with the implementation of the director's office and the associated work, that it is going to draw upon the already stretched resources of the BSCC staff. And is that being considered, and how is that being
yeah, and I think
accommodated?
Katie referred to the BCP that we have in to staff that portion of the agency. So we won't be drawing from current resources.
That's right.
Because you make an excellent point. At least we hope not to be drawing from current resources.
Right.
And,
Okay.
it's fair to say that, 519 is emerging. And so if we seem as though we don't have all the answers, it's because we're really planning and proposing budget items as fast as we can, because it will be here very soon.
And just to add to that, Madam Chair, we're actually not permitted to share what we've asked for. It's a confidential budget planning process with the governor's office now. So we'll know in January. We might know a few weeks before, but we just do not have that information yet, and we're not able to share it just yet.
Anybody else from the board?
Is the position you're saying July 1st, will they be in the position July 1st? Or will they open up the position July 1st?
Well,
That'll be a governor's
Yeah, that's-
office decision. We certainly hope the person will be in place by July 1st.
Yeah.
I mean, they really need to be, but we don't know the exact timing yet.
Anybody? Okay. And to those online, remember, we're going to finish the information session following our closed session. And there's a bit of a new process for people to link into the public comment section. So we're holding instructions and that until after our closed session. And I
That was a
just-
great idea, Madam Chair,
was an
by the way.
excellent
It was
idea.
super great. Yeah.
Yeah, well, every once in a while. And thank you to both of you for your presentation. Super informative. I've heard all of this many, many times. And doing this for the board members is super helpful. Looking at how we are resourced and how much work is being done is impressive and compliments to the FSO staff who are tireless. And then we asked a million questions on top of that internally, and then we come to these meetings and even more examination and questions occur. So it's a really big deal.
Thank you so much, Madam Chair. Really appreciate that and agree with all the praise to our